Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, we're going to talk about the pistol brace rule. Now, I enjoy talking about that about as much as I enjoy talking about solvent traps or root canal surgeries. However, there has been some late developments. It's going to prove that the old adage, it's better than late than never, is in fact actually true, especially if you've been relying on the NRA to bail you out of this problem. So today we're going to tear through an opinion, a ruling that we just got. It's good news for members of the NRA. So let's talk about how the NRA finally got relief from the pistol brace rule. Okay, here's the case we are talking about today. We are talking about the National Rifle Association versus the Bureau of Alcohol, Tobacco, and Firearms. And it is a case that is filed in the United States District Court in the Northern District of Texas. It is a challenge to ATF's Pistol Brace Rule, which was published January 31st of last year. Now, for those of you who geek out on this channel, you will know that at times I have been critical of the NRA, and candidly, I think they give me a lot of material to work with. And during the pistol brace litigation, one of the things that we were really critical of the NRA of was that they just kind of seemed to be late to the party at all times. Oh, sure, the Second Amendment Foundation, Firearms Policy Coalition, Gun Owners of America, National Association for Gun Rights, National Shooting Sports Foundation. Oh, they were all out there immediately out of the starting blocks representing their clients. But the NRA was quite late to the party. And if you recall, they actually tried to join on to one of the other suits, a suit called Mock v. Garland. And the court there said, no, actually, we're just going to leave you on the sideline, which required the NRA to turn around and file its own lawsuit, which they have done. Now, because they were late to the party, we were late getting a result here. But this is the good news for all of you NRA members who might own a firearm with an attached stabilizing brace is full injunctive relief has been granted to all NRA members now against ATF's pistol brace rule. Now, how much of a victory is this really? I'm not certain. When I was at SHOT Show in January, I specifically asked several members of the ATF, are they enforcing any portion of the pistol brace rule right now? The answer I clearly received was no, they are not. So they kind of know that this rule is dead in the water. But like I say, this is a good ruling here, and I want to share some of it with you. For those of you who don't recall why it was that we were completely freaking out over the pistol brace rule, let's recall that what occurred, according to the plaintiffs here, it actually were the final rule arbitrarily reverses several years of settled administrative practice by a stroke of a pen, redefines pistols with stabilizing braces as short-barreled rifles, subject to the onerous licensing and taxation requirements of the National Firearms Act of 1934. The new definition of rifle promulgated by the ATF now turns on an incomprehensible six-factor test that is based on ultra-subjective criteria about a firearm's likely use and the parsing of marketing materials that a gun purchaser may never have even seen. And of course, another big problem then with that rule was, because of the final rule, the millions of Americans, including many of the nearly 350,000 NRA members in Texas and over 4 million members nationwide, who own a pistol and a stabilizing brace, regardless of style or caliber or type of brace, must either dispose of, alter, or register their firearm. Otherwise, they face the prospect of 10 years in prison and larger fines. The NRA therefore takes the position that the risks associated with the final rule and these potential penalties irreparably harm its members, and it seeks declaratory judgment and preliminary injunction to protect its members from the enforcement of the final rule. Now, as I have always said, this was kind of a Me Too argument. So to suggest here that the NRA has done a bunch of brilliant lawyering, no, actually, they just kind of cut and pasted here and did a Me Too argument. Don't believe me? Here's how the court put it. The NRA contends that its members are similarly situated to the plaintiffs in Mock v. Garland and are entitled to preliminary injunction based on the Fifth Circuit's reasoning in that case. According to the NRA, the court in Mock implicitly found irreparable harm arising from the final rule, along with a likelihood of success on the merits, in holding that the plaintiffs, before the court and their members, should be protected from enforcement of the final rule and in issuing a preliminary injunction. Despite all of those criticisms, the NRA did a really, really nice job here in litigating a very important point, which is whether or not there was actually Article 3 standing. But it's just a fancy way of saying, hey, listen, can the NRA establish that they as an organization or any one particular member has actually suffered any harm from the publishing of this rule? And this is exactly where the Solicitor General and the Department of Justice worked overtime to try to get an out, try to get the escape hatch here so the court would not reach its ultimate findings. In response to plaintiff's motion, defendants contend that the NRA lacks standing to seek injunctive relief on behalf of its members because it has not met its burden of establishing associational standing. In this regard, defendants contend that the NRA has failed to identify a member who has suffered the requisite harm and has standing to sue on his or her own right because the member has sustained or is immediately in danger of sustaining some direct injury as the result of the final rule. And listen, this was a real weakness in the NRA's position. As the court pointed out, to establish Article 3 standing, the NRA has the burden to demonstrate that 1, it suffered an injury in fact, 2, that it is fairly traceable to the challenged conduct of the defendant, and 3, that it is likely to be redressed by a favorable judicial decision. And what may have actually been the saving grace here is at the preliminary injunction stage, the level of proof that's necessary to establish that standing is less significant than had we been much deeper in the case, as the court found. At the preliminary injunction stage, the movement must clearly show that only each element of standing is likely to obtain in the case at hand. The movement, however, need not show that it was literally certain that it would be injured. And so ultimately, where the court was able to go, with a lot of good finagling here by the attorneys for the NRA, the court specifically ruled, because the NRA seeks a preliminary injunction on behalf of its members, it must clearly show that a likelihood of at least one of its members suffered an injury. And so it was through this traditional membership organizational argument, a good argument on behalf of the NRA, that they were able to overcome what was really a tricky hurdle in advancing this lawsuit. The NRA's evidence is sufficient to establish that it is a traditional membership organization because it has members nationwide who, by donating to their organizations, have joined voluntarily to support the organization's mission of protecting law-abiding gun owners and their communities. Under the Supreme Court's decision in Students for Fair Admissions, Inc. v. President and Fellows of Harvard College, that is all that is required. A critical mistake was this. When the NRA decided that they were going to have to file their own pleadings, they did not really make any of the arguments that the ATF had grossly exceeded their statutory scope as defined in the Administrative Procedural Act. And as we know, the reason that the pistol brace rule has really been falling apart and just going nowhere as far as the courts are shutting this thing down left and right is because it clearly does violate the APA. Problem for the NRA, they didn't plead that originally. And here's where I think the court actually kind of bailed the NRA out a little bit. Because as the court specifically ruled, the NRA did not argue in its initial brief that the final rule violates the APA on the ground that it is not a logical outgrowth of the proposed rule. Defendants nevertheless were aware before filing their response to the NRA's motion that plaintiff was relying on this claim and the logical outgrowth analysis in mock because it was defendants who brought the issue to the court's attention in responding to plaintiff's motion. That's right. The NRA didn't raise it, but the United States government accidentally did raise it and thus opened the door for the NRA to make its arguments. Better to be lucky than good. Based on the reasoning in mock, the court similarly determines that the NRA is likely to succeed on the merits of its claim that the final rule violates the APA because it is not a logical outgrowth of the proposed rule. Now, you guys have geeked out on the channel long enough to know that when we're asking for an injunction, we really have to show two things. It's technically four, but we like to simplify things here. Number one, that there is absolutely irreparable harm occurring, and absent an injunction, that irreparable harm will continue. And then number two, that the plaintiffs, the people seeking the injunction, are likely to succeed on the merits of the argument. In finding irreparable harm, the court specifically ruled, consequently, that Dr. Carlson or other NRA members could have registered their firearms tax-free during the grace period to avoid the $200 registration fee is quite beside the point. because any cost incurred by the NRA's members will be unrecoverable due to defendants' sovereign immunity from money damages and the likely reality of NRA members facing criminal penalties and fines for non-compliance during the pendency of this lawsuit, the court determines that the irreparable harm requirement for injunctive relief is satisfied here. And then finally, and most importantly, especially for you NRA members that were still spooked by the Pistol Brace Rule, the court's actual ruling as it relates to remedy reads as follows. For the reasons explained, the court concludes that the NRA has associational standing to sue on behalf of its members and has met its burden of establishing each of the 4 requirements for a preliminary injunction. The court therefore grants the NRA's motion and request for a preliminary injunction, and it enjoins the ATF, Stephen Dettelbach, in his official capacity as the director of the ATF, the United States Department of Justice, and Merrick Garland, in his official capacity as the United States Attorney General, from enforcing the final rule against the NRA's members pending the final resolution of this action on the merits. And hey, like I say, it's the result that matters. Better late than never. Congratulations to the NRA and its members. You are officially free for the time being from the confines of ATF's Pistol Brace Rule. The case, once again, is the National Rifle Association versus the Bureau of Alcohol, Tobacco, and Firearms. We will link up the court's order down below so that you can geek out on it for yourself. If you got any other questions about this, or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. If you don't, that's okay. That information is also down there in the description box. And then finally, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.